Hey folks, welcome to the Law of Self-Defense ongoing coverage of the Kyle Rittenhouse trial. I am, of course, attorney Andrew Branca for Law of Self-Defense. And good news, the Kyle Rittenhouse trial is finally underway with voir dire, or jury selection, having begun this morning. Some highlights of today's voir dire include the defense voir dire suggesting that Kyle Rittenhouse might testify at trial. Judge Schroeder contextualizing jury security concerns by noting that even judges hardly ever get assassinated, a juror excused because his Second Amendment beliefs would not allow him to be impartial, a juror excused because her hatred of AR rifles would not allow her to be impartial, a juror excused because she understood "thou shalt not kill" to be literal, and Judge Schroeder instructing jurors on the difference between semi-automatic versus machine gun. And there's a lot more, so let's dive right in. Before I do, however, I do want to mention the sponsor of today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay its members' legal expenses if the member is involved in a use of force event, and those expenses get big fast, folks. It's not unusual in a murder or manslaughter charge case to go through $200,000 before you even get to trial. So if you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depended on it, because really it does. Now, I've looked at all the companies that offer these types of services, and I found that CCW Safe is by far the best fit for me. I'm personally a member of CCW Safe. My wife, Emily, is personally a member. Whether they're the best fit for you is something only you can decide, but I do urge you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member there, you can save 10% off your membership using the discount code LOSD10, that's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCW Safe. Okay, let's jump back into the Rittenhouse jury selection process. So trial judge Bruce Schroeder has decided that he wants to end up with a seated jury of 20, which would include 20 jurors who will deliberate a verdict and 8 alternates. Now, which specific jurors are alternates will not be determined until just before deliberations begin at the end of the trial. Judge Schroeder has also allowed each side to have 7 peremptory strikes for a total of 14 strikes. So the judge is looking to put together a group of 34 qualified jurors from which 14 can be struck, leaving that goal of 20 jurors to be seated. In this context, qualified jurors appears to mean a group of jurors from whom the court has already removed everybody who should be struck for cause. Some conflict of interest, unable to be impartial, important schedule conflicts, and so forth. That is, in other words, the general voir dire part of the jury selection process. Once the group of 34 have been established, the parties will engage in individual voir dire or individual questioning, where each party can question individual prospective jurors to determine if they wish to exercise one of their 7 peremptory strikes on that particular prospective juror. Working towards that group of 34 qualified jurors is what Judge Schroeder and the parties engaged in for the bulk of today. Judge Schroeder welcomed the prospective jurors, actually starting today with an impromptu game of Jeopardy as everybody got settled. He then named the defendant, Kyle Rittenhouse, and read out the charges against him with a brief factual description of each, carefully noting that each was at present merely an allegation by the state. These charges consisted of the 6 criminal charges, which I overviewed in our blog post yesterday, with an additional 7th charge of violating curfew. But this last charge, however, appears non-criminal in nature. It's only a ticket offense, and so the state's only required to prove that one by clear and convincing evidence. Each criminal charge must, of course, be proven beyond a reasonable doubt, or the jury's obliged to acquit on that charge.
I'm going to introduce the case to you. It's entitled "The State Against Kyle Rittenhouse," and when a person or entity feels that some wrong has been done that can be addressed by the law, a complaint can be filed with the clerk of the court, asking for some legal action to be taken. And that document is known as exactly that, the complaint. And that's where the word plaintiff comes from. The person or entity which files the complaint is the plaintiff, and in a criminal case, the state is always the plaintiff and is typically represented by the district attorney of the county, and in this case is represented, the case is presented by Assistant District Attorney Thomas Binger and Assistant District Attorney James Krause. The person against whom this complaint is brought is known as the defendant because of the role of defending the action. And the defendant in this case is a gentleman by the name of Kyle Rittenhouse. And he is here with his lawyers, Mr. Mark Richards and Mr. Corey Sharafacy and Ms. Natalie Wisco. And after some preliminary activity has taken place on the case, the district attorney makes a formal charge selection and presents it to the court in a document which is known as the information. It gets its name from its informative function, and it can contain one or more allegations or charges of criminal activity. You hear that referred to in your experience in life or on television or whatever as counts. And in this case, the information contains 7 counts alleging various levels of unlawful activity. The first charge is charges that on the 25th of August of 2020 at the city of Kenosha in this county that the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life. This is a crime which is literally known as reckless endangerment of reckless homicide of the first degree. The second count charges the defendant with another charge is first degree recklessly endangering safety, and alleges that at the same time and place the defendant recklessly endangered the safety of another, Richard McGinnis, under circumstances which show utter disregard for human life. The third count charges that the defendant committed an additional crime of reckless endangerment of the first degree at the same time and place by recklessly endangering the safety of an unknown person under circumstances showing an utter disregard for human life. The fourth count charges that at the same time and place the defendant caused the death of Anthony M. Huber with intent to kill that person. This is a charge literally known as intentional homicide of the first degree. The fifth count charges that at the same time and place the defendant attempted to cause the death of Gage Grosskreutz with intent to kill that person. This is a crime literally known as attempted intentional homicide of the first degree. The sixth count charges that at the same time and place, the defendant, being a person under the age of 18, did go armed with a dangerous weapon. This is a crime literally known as possession of a dangerous weapon by a person under 18. And the seventh count charges that at the same time and place, the defendant committed the crime, the unlawful act of failing to comply with the order of with an order of local government emergency management activity, alleging that he intentionally failed to comply with an order issued by an agent of the state or of a local unit of government who is engaged in emergency management activity under Chapter 323 of the statutes, including training exercises. And so to each of these charges, I should add also that with respect to the first 5 counts, the district attorney alleges that the crime was committed while the defendant was armed with a dangerous weapon, using a dangerous weapon. To each of these charges in the information, the defendant has entered a plea of not guilty, which is a demand that every material allegation of each of these counts be proved with respect to the first 6 counts beyond a reasonable doubt, and as to the 7th count, by evidence which is clear, convincing, and satisfactory to a reasonable certainty. And I'll talk later about the burdens of proof. The defendant is not obliged to prove his innocence. The entire burden of proof is upon the district attorney to establish the guilt of the defendant beyond a reasonable doubt. If the state is unable to sustain that burden, then the jury is bound to find the defendant not guilty.
Of today's content. Judge Schroeder then provided a general narrative of the events that evening of August 25th, 2020, that resulted in the cited charges. And this description of events mostly framed along the lines of the district attorney's claims of those events.
Well, let's start with that. Is there anyone of you who is related by blood or marriage or adoption to or acquainted with the defendant, in this case, Kyle Rittenhouse? Is there any one of you who knows any of his family or kin? Does any of you know any of the attorneys whose names have been mentioned here, or has ever had any business or professional or social dealings with any of them, or been involved in a transaction in which one of them was also involved? I'm going to ask well, I think first I'm going to give you some background on the case, and this case has enjoyed a lot of publicity, and we're going to talk about that in a little bit as well. But I'm going to give you some of what the complaint alleges, because the information is a formal statement of the charge, but there's more of the district attorney's factual assertions contained in the complaint. And it is alleged that on the night in question, there was a good deal of public unrest in the central area of the city of Kenosha. And it is alleged that the defendant, Kyle Rittenhouse, was in Kenosha at that time, that he was armed with a rifle, and that also in the city at that particular time were Joseph Rosenbaum, Richard McGinnis, this unknown person who was referred to in the third count, Anthony Huber, and Gage Grosskreutz, and that during the course of the evening, there was a period when there was close contact between Mr. Rosenbaum and the defendant, and the district attorney alleges that it ended with the defendant firing a bullet, or firing a series of bullets, one of which brought about the death of Mr. Rosenbaum. With respect to Mr. McGinnis, he was in the close proximity of the incident in which that gunfire occurred, and that the district attorney claims that his safety was endangered by that. After that incident, it is alleged by the district attorney that Mr. Rittenhouse started moving northbound on Sheridan Road. And the incident, by the way, involving Mr. Rosenbaum is alleged to have occurred down at 63rd and Sheridan in a place called the Car Source. And then after that, it is alleged that Mr. Rittenhouse was walking down the center of the Sheridan Road, northbound, and at one point there were other people in the street who appeared to be in pursuit. The district attorney claims in his complaint that Mr. Rittenhouse stumbled and fell, and then there were a series of people who came into close proximity with him, and that at that point he began firing at three of them, the unknown person, Mr. Grosskreutz, well, next Mr. Huber, and then Mr. Grosskreutz, and that he missed his shot or shots involving the unknown person. Mr. Huber was fatally struck, and Mr. Grosskreutz sustained a gunshot wound. And that's what the case is about.
Now, Judge Schroeder, interestingly enough, before beginning general voir dire, he had some introductory remarks for the jury about the importance of jury selection, as is commonly the case at the start of the jury selection process. Perhaps less commonly, Judge Schroeder went beyond the typical "it's a civic duty" spiel to also specifically reference the founding fathers, as well as ancient Greek and Roman history, as well as the period we used to refer to as the Dark Ages when I was a school kid. Judge Schroeder noted that the founders were very specific about putting a right to a jury trial in the Constitution, and not merely any jury, but a fair and impartial jury of one's peers. He also noted that the founders risked everything in doing so, in leading the revolution, including staking their lives, their fortunes, and their sacred honor, quoting there directly from the Declaration of Independence.
This is about our Constitution. 1,000 years ago, a case like this would have been tried. Well, let's go back even further. Let's go back to I'm sure you remember it, the fall of Rome in 476. And when Rome fell, the world changed dramatically. And the ancient law which had developed from Greece and Rome, which involved jury trials, not the kind of juries we have today, but they were the resolution of legal disputes by use of reason, and that fell with Rome, and some very primitive methods came into use to decide legal disputes, including criminal cases. Sometimes I saw somebody at one of my grandkids' games a month or so ago, and he was wearing a shirt that said "Demand trial by ordeal." No, "Demand trial by combat." And I thought, what an unusual shirt. But because I talk about this once in a while, I thought it was kind of interesting. I guess it turns out that there's a program on television that deals with that. Is anybody familiar with that? Well, there's some program on TV that has dealt with the concept of trial by combat, and I think there may be a movie coming out about it. It actually was true 1,000 years ago that people who are having a legal dispute, including in criminal cases, could either themselves or hire someone to fight for them, and they'd fight with the other side physically, and there'd be an ecclesiastical blessing. A priest would bless it, and it was decided that God would guide the hand of the innocent, and that the innocent person would win that fight, and that would be the outcome of the case. They also had something called trial by ordeal. And the concept was that a person would be made to walk across, for example, a bed of coal, burning coals, or stick her hand or his hand into a boiling water. And depending on the healing period, if the person recovered sufficiently, and this was blessed, so that it would be a message from God, that was determined. If he didn't come out too badly, he was innocent. If he did, his punishments had just begun. So that's how they actually decided cases. And then in 1215, Pope Innocent III prohibited priests from participating in these ceremonies. So they had to turn to some other way to determine these issues, and they moved back towards the jury system. And the initial juries were actually made up of people who knew the people involved. People who had either been witnesses, who saw what happened, or people who were acquainted with the people and knew whether they were honorable people, whether they were violent people, whatever the case might be. They had some knowledge of the people, and they'd get together and they'd talk it over and they'd come up with a verdict. Well, what's the number one problem that you would see with a system like that? Bias. Because if the witnesses, well, the people you were with. So the people who were with one side might well side with family members, might side with somebody. So they decided to get away from that. This didn't happen overnight, but they decided to get neutral juries who would hear testimony from the people who actually knew something. And that's the system that continues to this day. That's why you're here. And you're here because the founders of our country didn't trust me. They didn't trust any judge. They knew the abuses that had occurred, even with the jury system. They knew the abuses which occurred under judges who were appointed by the king. And so they were hand-selected. And then they were still responsible to the king to get paid. Or I should say, the king was responsible to them to pay them. So they felt that there was way too much influence on the judiciary to trust decisions of this magnitude, deciding a case like this. That should not be entrusted to judges. This should be decided by the people themselves. That's a system that's lasted 225 years. We're the oldest democracy in the world, in part because we have this important check on the government, which is trial by jury. That's why you're here. What goes with that is that there's something else. So that let me start over. The founders of our country were very firm about what was going to go into that Bill of Rights that was passed at the first Congress. And one of the ingredients was trial by jury. They wanted to protect that. It's in the Constitution, the basic law of this country. And it was carried over into the states so that both under the federal and the state constitution, people have a right to a trial by jury. And that's why you're here today. They put another provision in the Constitution entitled, well, the title isn't important. It is for a fair and impartial jury. That's an obligation that they imposed on you. These are people who had risked everything, their lives, as they said themselves in the Declaration of Independence, their lives, their fortunes, and their sacred honor. They pledged all of that, and they literally did. This was a capital offense when they rebelled against their lawful king. And gruesome execution. The forfeiture of all their property, there was something called corruption of blood, where not only were they disinherited, but their children. They would lose everything. And their sacred honor. Now, there's honorable people in this world today, but I don't think it gets the attention that it did in a former era. When people, well, Thomas More is a perfect example, who was the Chancellor of England, and it was the expectation of the king that he would swear an oath that the king, rather than the Pope, was the head of the church. And Thomas More didn't agree with that. All he had to do to save his skin was to take that oath, but he refused. He didn't deny the king's title, but he simply refused to swear that he believed the king to be the head of the church. And as a result, he was beheaded. That's sacred honor. And that is what these people pledged when they gave us our freedom in 1776. And then again, it's what they expected when they created our Constitution, the Bill of Rights, after the formation of the United States under the Constitution. So they specified a fair and impartial jury, not just a jury that's going to be motivated by one influence of another. This case has become very political. It was involved in the politics of the last election year. To this day, you could go out now and read things from all across the political spectrum about this case, most of which is written by people who know nothing I don't mean that they're know-nothings. I mean that they don't know what you're going to know, those of you who are selected for this jury, who are going to hear for yourselves the real evidence in this case. But there's something called the First Amendment, that's another part of our Constitution, where they guarantee the right of a free press. And it's the price we pay for having a free press is a lot of irresponsible and sloppy journalism. This is not an attack on the media. I've read things about this case that were perfectly stated what had happened in this court. And there are things that I think, was I in the courtroom when that happened? It can be frightening. So I'm not bashing anybody, but I'm going to talk about what you need to do, what you need to be thinking about if you're picked to hear this case, and how much reliance you can put on things that may be just sloppy, which is a vast amount of it. Some of it that is deliberately biased, that's out there, and sometimes from respectable media outlets. But that's the price we pay for having a free press, because we value that. But we also value having a fair trial. So the critical thing you must remember is whatever you've read or heard about the case before, whatever you've been thinking about the case, you have to be in line with what these people who risked their lives for our freedom asked of us, demanded of us. Fair and impartial based upon the evidence. Those who are picked for this jury will be in the front row seat to see exactly what happened and make a rational decision based on that. And anybody who's not on board with deciding strictly on the evidence needs to tell us that. If you can't do that, then you can't be fair, and you're not in step with what the founders expected and demanded.
Now, Judge Schroeder acknowledged that the case had become unfortunately politicized and had some considerable criticism for the irresponsible and sloppy and sometimes deliberately biased reporting of the case by the media. He said it's fine if the prospective jurors had been exposed to such coverage, and even fine if they had developed opinions based on such exposure, but they would need to be able to set aside any such exposure and opinions and arrive at a verdict based solely on the evidence and legal arguments made in court and the law as Judge Schroeder instructed them. Judge Schroeder then began general voir dire of the group of 34 prospective jurors, first asking if any of them might be unable to disregard what they had previously learned about the case and unable to decide the case solely on the evidence in court. And at least 7 of the group of 34 raised their hands on that question. But at this point, rather than dive into those concerns in detail in the moment, Judge Schroeder first had the state and then the defense read out their respective list of possible witnesses that they might call during the trial, asking the prospective jurors to raise their hands if they were related to or knew any of the persons named. This took quite a while, as it seems the state alone has some 150 possible witnesses on their list, only a small fraction of which will actually be called to testify at trial, of course, and the defense had about 50 people in their list. And there were occasional prospective jurors who raised a hand at a given name, and these were flagged for further questioning during individual voir dire. After reading the witness list, Judge Schroeder returned to general voir dire, asking if any of the prospective jurors had previously formed or expressed an opinion as to the guilt or innocence of the defendant. And here is where the court began to excuse for cause, so no peremptory strikes needed to be used by the parties, excused for cause a substantial number of prospective jurors from the group of 34, replacing each with another prospective juror drawn from the broader jury pool that was also available in the courtroom. Now, not everyone who professed to have a previously expressed or formed opinion as to guilt was excused for cause. If they were able to tell the court that they could set that opinion aside and deliberate the case on the evidence in court, well, then they made it past general voir dire by the judge. That said, at least 10 prospective jurors were excused for cause because they insisted that they could not set aside their formed opinion on guilt regardless of what evidence they might see in court. Most of these had apparently come to an opinion of guilt based upon the year or so of propaganda in which Kenosha County has been awash since the shooting in August 2020. One male prospective juror, number 17, however, professed that he could not be impartial, not because of the propaganda, but because of his abiding faith in the Second Amendment.
Okay, anybody else? And the last question was if you've ever formed or expressed any opinion, now have or express any opinion as to the innocence or guilt of the defendant without hearing the evidence. What's your number, sir? 17, and what's up?
My biases go back to 14 months ago. I've been commenting consistently on news feeds and Facebook. It also goes a little further to my belief in the Second Amendment, which comes from Monroe's writings in the Federalist Papers.
I'm going to stop you.
Judge Schroeder quickly interrupted number 17, pointing out that this was not a political trial, despite the extent to which the media and politicians had sought to make it political. In this courtroom, Schroeder told them, we only care about the evidence and the law. Schroeder wrapped up his remarks by noting specifically that Second Amendment issues were not at the core of this case. Unfortunately, that several-minute talk by the judge had little effect on prospective juror number 17, who was firm that he could not be fair and impartial and was dismissed for cause. And
anybody, if you've said something about the case, we want to know about it for sure. But I just don't want to get into a discussion now where we're talking about the Second Amendment or anything like that, because this case is not the Second Amendment, like all the constitutional provisions, have a role in this case, but they are not the focus of this case, okay? If I'm going on, bear with me. Okay, so do you think you can be fair in this case?
No, I do not.
Do you think that there are other people here who are going to be fairer than you would be?
I have no idea how to answer that.
Okay.
I would hope so.
You think you're biased?
Yes, I do, and it goes back to the politics that you told me to stop.
No, okay. Any reason this gentleman shouldn't be excused?
No.
Okay, thank you, sir.
another prospective juror, a female, prospective juror number 10, had an interestingly ill-informed understanding of the sixth of the Ten Commandments. Although the sixth commandment is commonly written out as thou shalt not kill, it's more properly understood to mean one shall not kill unlawfully. There are few followers of the Ten Commandments who do not acknowledge a privilege to kill in lawful defense of innocent life, for example, or to kill in necessary combat in defense of one's nation. Juror number 10, however, took the absolute literal view that, quote-unquote, God's law informed her that one may not kill under any circumstances, even under conditions of lawful self-defense. Judge Schroeder respectfully suggested that the court was a secular entity within a society that allows for killing, if necessary, in lawful self-defense, but juror number 10 could not be budged, so she was dismissed for cause on that basis. And here's a little clip of that exchange taking place.
This is number 10. What's up?
For religious reasons, I firmly believe that thou shalt not kill. I don't know what else to say. That's my opinion. It's been that way for a year now. Throughout this whole riot and everything, I'm just petrified most of the time to even go out. I've got an alarm and cameras on my house now, and I live alone. And like I said, thou shalt not kill.
Well, let me, and I understand that, and I don't want to suggest that you should do anything in violation of the religious beliefs that you hold. However, I think most religious faiths accommodate the belief in self-defense, and that's going to be an issue in this case. The state is contending that these crimes were committed. The law provides that self-defense is a defense and that people have the lawful right to defend themselves. I think most religious groups believe that. I think that when, for example, during the attack on Pearl Harbor back in 1941, the members of our military, the sailors, were on the ship, and all of a sudden planes come and start shooting at them and dropping bombs on them. I think most religious belief would be that they could morally return fire and try literally to kill those who were attacking them to save their own lives and those of their colleagues. So I want to make sure that those. I think that a large segment of the group here, perhaps everybody who's here, would agree with the proposition that thou shalt not kill, but will be open to what moral belief is. But more importantly, because we have secular institutions in this country, in this court here, we are bound by the law of the state, and regardless of your personal beliefs on the subject of the morality of self-defense, if it is self-defense, I'm not saying it is, if it's self-defense, it is our law that the jury is not to convict if the jury believes that the defendant acted in self-defense. And I don't want to get bogged down on that right now, but do you think you can follow our law, whether or not you agree that that should be the law, and that you think that it should be, you should turn the cheek? Do you think that you can follow the law in terms of making your verdict and examine the evidence and decide whether the case is self-defense? Can you do that?
No, I have to follow God's laws.
Okay. Any reason this juror shouldn't be excused? Thank you, ma'am.
About that time, the court recessed for lunch, and when the court returned from lunch, there was a handful of additional general voir dire from the court. A few more prospective jurors were dismissed for cause, and then it was the state's turn for general voir dire. This was conducted by Prosecutor Binger. He reminded the prospective jurors that the protests last August had been the result of a Kenosha police officer shooting Jacob Blake on August 23rd, 2020. He asked if any of them had participated in those protests. None had, but several had friends or relatives who had participated or attended. One prospective juror was dismissed for cause when she indicated that her granddaughter attending the protests made her unable to be fair and impartial. Binger asked if any of the prospective jurors had been personally impacted by property damage that resulted from the protests, and none had, although several had friends or family who had been personally impacted. None of the prospective jurors indicated this would keep them from being fair and impartial, however. Binger's next question would consume quite a chunk of his time on voir dire. He asked if any of the prospective jurors had taken affirmative steps to protect their property or themselves in response to the quote-unquote protests, and a large proportion of the group raised their hands. Several had moved vehicles from the front of their property to the rear. One removed a blue Support the Police porch light and replaced it with a regular bulb. Some helped board up their businesses or those of friends and family. Some moved their families out of the county for a few days. Others stayed overnight at their local church. One worked with a neighbor to establish a neighborhood watch just for that period. Interestingly, one female prospective juror told the court that her neighbors had urged her to take down the American flag on the front of her home in fear that it would make her a target for attack. Instead, however, she went out, purchased her first ever firearm, and left her flag exactly where it was. Binger asked if any of the group were familiar with guns, and a large portion were, either through hunter safety courses, or hunting itself, target shooting, and several for personal protection purposes. When asked about medical issues that might interfere with their jury service, several prospective jurors claimed such conditions, and a few were excused for cause, but others were not. A few prospective jurors expressed concern about how family might react if they came back with a verdict the family did not agree with. One woman was concerned about how her husband would react, given his extremely strong position on the case. She was ultimately dismissed for cause on that basis. And another worried about what Thanksgiving dinner with the family would be like with her PTSD retired police officer relative present for Thanksgiving. His PTSD was in part because of the Kenosha protests. Binger spent a considerable time collecting employment and highest degree of education information from the pool of prospective jurors, and that was about it for the state's general voir dire. So then the defense general voir dire took place, led by attorney Corey Chirafisi. The general voir dire defense questions seemed largely focused on fear the prospective jurors might have felt during the riots, whether for themselves, their children, their relatives, their neighbors, their friends, as well as fear they may be feeling even today if called to serve on the jury. And this is a smart play by the defense because it helps replicate the emotional state many people would have been feeling at the time of the protests, and certainly that Kyle Rittenhouse was feeling as he was repeatedly attacked with deadly force on the night of August 25th, 2020. The more the defense can put the prospective jurors in Kyle's shoes, the better the prospects for acquittal and the more difficult the challenge for conviction. The defense counsel also asked the prospective jurors about guns, and again, many indicated a substantial degree of familiarity with firearms, and at least one female juror noted once more that she'd never owned a gun previously, but had purchased one for personal protection precisely because of the perceived danger presented by the protests. Defense counsel asked if any of the prospective jurors believed that someone who brought a firearm downtown must be guilty of something, but no one indicated that they did. Similarly, he asked if any of the group believed that if someone violated the curfew, a ticketing offense rather than a crime, that they were responsible for everything that happened afterwards. And again, no one indicated that they believed that. Interestingly, prospective juror number 30, a woman, reacted poorly to defense counsel informing the group that the firearm in this case was an AR-style rifle. He pointed out that the particular rifle in question was technically called an MP-15, but that it might be referred to as an AR-15 during the trial. Number 30 announced that, yes, she did have a problem with it, saying that she didn't believe that a weapon like that should belong to the general public, even if it was legal to purchase. When asked by defense counsel if she thought she could judge the case fairly if it involved a legal firearm that she thought should not be legal, she answered no. And not surprisingly, defense counsel immediately moved to strike her for cause. Judge Schroeder, appropriately enough, asked if the state had any objection to this, and Binger took the opportunity to dig a little deeper on this question. He asked the woman whether just the simple fact that if the evidence showed the defendant possessed an AR-15, did that mean she would just find him guilty of all the charges based on that fact alone? Pretty much, she answered. And that was it for prospective juror number 30, who was dismissed for cause without objection by the state.
The firearm in this case, I think it'll be referred to as an AR-15. It's an MP-15, but it's referred to that. Is anybody so bothered by that type of firearm that they don't think that they could listen to the facts of the case and judge it fairly? Anybody have such a problem with that? Okay. I want to make sure I have it right. I'm not going to have it right. Juror number 30. Okay.
So yes, I do have a problem with it.
Okay. Can you, I don't want this to sound like a dumb question, but can you just tell me your feelings on it?
I don't think a weapon like that should belong to the general public.
Okay. If it's legal to purchase, and you have your feelings, which are, I'm just going to complain about that. And the firearm in and of itself isn't illegal. Do you think you can judge this case fairly, understanding that it involves a firearm that you don't think should be legal?
No.
Okay. So you think you would be, you would have difficulty setting aside whatever preconceived notions or whatever your feelings are about the case and judge it fairly?
Yeah.
Okay. Judge, I would move to strike 30.
Okay. Go ahead.
Ma'am, I just want to clarify something. So there are going to be a lot of facts in this case about a lot of different things. Counsel's asked about the curfew, about the events of that night, protests, things like that. Am I understanding you correctly that just the simple fact that if the evidence shows that the defendant possessed an AR-15, you would find him guilty of all of the charges just based on that fact?
Pretty much.
Okay. Then I have no objection.
What was the answer? Pretty much.
Yes.
Okay. All right. Thank you, ma'am. I'm going to excuse you.
Now, later, another female prospective juror stated that she felt much the same about the case if a machine gun was involved. Of course, Kyle's MP-15 was merely a semi-automatic rifle, not an actual machine gun, but many people not very knowledgeable about firearms might perceive an MP-15 as a machine gun simply because of its appearance. This led to a bit of an unwieldy exchange, as defense counsel clearly wanted to inform the woman that the rifle involved was not a machine gun, but generally speaking, the lawyers during voir dire are not supposed to touch upon specific facts of the case. This led to Judge Schroeder interjecting to get the process over this bit of a procedural hump, and he took a few moments to explain the technical distinction between a genuine machine gun and a mere semi-automatic rifle. Ultimately, the woman indicated that she wouldn't have a problem with the firearm, in particular if it took a deliberate decision to fire each shot as opposed to it just taking everybody out.
You sure can. Juror number 31.
Okay, earlier you had asked about the type of gun that it was and how comfortable we were with that type of gun. In my opinion, the only type of gun that I would have classified that as a machine gun. And I raised my hand, but we got disturbed by something. So that being said, I just wanted it noted that, no, I don't believe a machine gun should be in anyone's hands.
So I don't know a whole lot about firearms. Can you tell me what your definition of a machine gun is?
A machine gun that is able to shoot multiple rounds.
When you say that, by like you just hold the trigger down and then bullets just keep coming?
I'm not sure.
Okay.
But I don't think that type of gun is necessary for the public.
Well, you're going to, this case is going to involve a gun that you may be, I don't want to say uncomfortable, but
Yeah.
your feelings on it, okay? So I don't think I'm going to
Okay.
sugarcoat this.
I just wanted you to know.
You're going to hear that that gun is out and about in Kenosha. How would...
It is and it shouldn't be.
Okay. With that belief, do you think you can still listen to the case and judge it fairly, or are you bothered enough by your feelings about the type of firearm that you would be unwilling to set that aside?
That's rude.
I appreciate you being honest about it. I think everybody does. So
I would try my best to try to be very neutral about it. I would try my best.
So the judge has asked, do you think somebody could do a better job than you sitting in your chair?
Nobody wants to be in this chair, I'll tell you that.
You said nobody wants to be in the chair?
Nobody wants to be in this chair. I'd be rather sitting in a hard bench.
Okay, I'll get back to that in a second, but I'm really just, and I think everybody just wants the people that are going to be as fair as possible. And if there's something that is telling you that you don't think that you can be as fair as possible, I think everybody on this side would want to know that. Do you think, with the feelings that you have, I think it's a, I don't want to say it's a yes or no, but what are your feelings on that?
I would try to be fair for everyone's both sides of it. I just really feel as if I'm taking it away from just the gun itself. I don't like that gun. It's my opinion.
I think I'm going to interject. I'm going to invite correction by the lawyers because you've used the term a machine gun. And there was a time 50 years ago when a machine gun was a gun that on a single depression of the trigger would fire multiple rounds. That type of gun still exists and, for example, is used in the military. They are unlawful in almost all instances for sale to individuals. That's called now a fully automatic weapon. That means that the single trigger depression can discharge as many bullets as the firearm is capable of discharging for as long as the trigger is depressed. Then there are guns that are semi-automatic, where they're capable of firing a large number of rounds, but every time requires a single trigger pull. There have been devices created which can render those effectively fully automatic. They are not lawful for sale in this country, but I think the old ones are still out there, which would make the gun the equivalent of a fully automatic weapon. So there's semi-automatic, single depression, discharges only one bullet, and it's as fast as you can pull your trigger, the number of times you can pull the trigger. And there's the fully automatic, which will fire as long as it's held down. Does that make sense? Anybody have a question about that accuracy of that? Okay, go ahead now.
Would it matter to you whether or not, how would it change your opinion if you knew that it was not fully automatic, that it was a single depression? Would that change your opinion and how you feel?
The intent to shoot a particular person
Mm-hmm.
or thing would be more deliberate than if it was a machine gun and you're just taking down everybody. Machine gun being automatic, I guess, is a word I should have done.
So I just want to make sure that I understand your position on it. Okay, so the judge has told you about no one here is going to allege that there was an automatic weapon used. Okay? So it was a single depression, as many times as the judge said, as fast as you can pull the trigger, but it's a semi-automatic weapon. Knowing that, does that have an impact on your feelings in terms of being able to judge the case fairly?
I guess I'd have to see how it all mapped out with the evidence.
Would you do your best to try to...
I will do my best.
Now, interestingly, defense counsel also asked the prospective jurors whether, should Kyle choose to testify, that they would find his testimony less credible simply because he was charged in this case. Now, no one of the group said they would, which is not surprising. What is surprising is the question itself, because it suggests that the defense is holding open the option that Kyle himself may take the witness stand and testify in his own behalf, always a high-risk gambit.
How about Mr. Rittenhouse has the constitutional right to testify and the constitutional right not to testify. Is there anybody here who would find him less credible simply because he is charged in this case? That no matter what he says, he's less credible as a witness? Anybody actually believe that to be true? I don't see any hands.
Defense counsel also asked several questions about medical training, particularly in the context of gunshot wounds, such artifacts of gunshot wounds as stippling, but none of the prospective jurors expressed any particular expertise or experience on the subject, including the two pharmacists and, surprisingly, the emergency medical technician who had training on gunshot wounds, but not much experience. A bit later, a couple of jurors spoke to what seemed to be the elephant in the room, noting that given how divided the community and the country was on such cases, no matter what verdict they returned, fully half the country would hate them. And they were concerned for their personal safety, as well as the safety of the community if there were renewed protests. One particularly vocal prospective juror on this issue, a woman, referred to her concern about the crazies who had rioted, looted, and burned the city the year before, returning to do the same if there was a verdict they didn't like. A couple of female jurors also indicated that they declined to drive their own cars to the courthouse for jury selection out of fear that someone might identify them or damage their vehicle. Now, here Judge Schroeder interjected, attempting to assuage some of these fears, but frankly, he did not show the smoothest touch. At one point, he tried to put the threat in a reasonable context by noting that, hey, he'd been in the law for 50 years, 38 years as a trial judge, and no juror had ever been harmed in his experience, which is all well and good. But then he added, rather unhelpfully, I thought, that even judges only get assassinated maybe once every 10 or 15 years.
34.
34. So I really want to serve on a jury. I really do not want to serve on this jury. I only want to serve on a jury where the people involved directly have an opinion. I figure either way this goes, you're going to have half the country upset with you, and they react poorly. I also drove somebody else's car here, and while it wouldn't, it is my duty, and you're a guilt tripper up there on the bench, and so I'm a big Hamilton fan, and you keep mentioning the Founding Fathers, but it's scary because you don't know how people are going to react, and I watch too much TV, and so of course you worry. I want to know who's going to have the list of jurors. I'm grateful that you mentioned that we're not photographed. Not only would I not have control over my good side, but I don't want it to be known. I don't want people to know that I'm on a jury, or, if I'm on a jury, I wouldn't want them to know, and I wouldn't want them to have my list of my name or my address. I don't want people standing outside of my house. It's scary when you think all of a sudden, and it's on the news all over the country. It's not just Kenosha County. So, it is scary, and I would be very interested to hear how the jury is protected, because...
Sure. And those are legitimate questions, and they recur in cases without commenting on the enormity of this case or its particular facts, the aura of fear that would surround it. If you were here over the years that I've been here, you would have a better idea about the degree of risk that's involved for jurors. I can tell you, one of the things I'll tell whoever's selected on this case, whatever their verdicts are, I will talk about you're never obliged to talk with anybody about the case, but you're welcome to talk about it as little or as much as you want. I tell them that if anyone bothers them, that they should let me know, and we'll put a stop to it. And you know what? In 50 years of trying cases, and I tried cases as a lawyer, and now in 38 years as a judge, I've never had a juror threatened. I've never had a juror bothered in any way. I have not been bothered, and I don't have any special arrangements either. I am involved differently, obviously, in the jury, but as you'll find later, if there's a verdict of guilt returned in a criminal trial, then I'm in the sentencing business, and I think that the fear that people have is greater than the reality of risk. I'm not going to say it could never happen. By the way, when was the last time you read about a juror being harmed?
Well, I watched a movie the other day.
Very good.
I'm a Netflix girl.
Okay, all right, I got you. But yeah, you don't hear about it. You once in a decade, once in maybe 15 years, you'll hear about a judge getting assassinated.
I can only imagine what the concerned jurors now thought of their personal risks when even the judge himself might be the target of an assassination. Defense counsel wrapped up with some routine questions on reasonable doubt, noting that the prosecution bore that burden both to prove the criminal charge beyond a reasonable doubt and also to disprove self-defense beyond a reasonable doubt. He also spoke to the presumption of innocence, ensuring that the prospective jurors were not expecting that the parties were both starting in the middle, but that the defense started with the presumption of being innocent. And that was about it for general voir dire by the defense. Now, with general voir dire over, the jury selection process next transitioned over to individual voir dire. This was not conducted in the courtroom, however. The qualified jurors were left in the courtroom, but pulled out one by one into the courthouse library for individual questioning. Unfortunately, that part of the day's proceedings, kind of late in the afternoon anyway, were not broadcast, so I don't have any particular insight to share there. Okay, folks, don't forget to please join us once again tomorrow for our live coverage of the day's proceedings starting first thing in the morning when court comes into session. I expect we'll discover then, first thing, just how far the court managed to get in jury selection today, but they certainly appear to make considerable progress. Okay, folks, that's all I have for you on this topic today, but until next time, remember, if you carry a gun so you're hard to kill, that's why I carry a gun so I'm hard to kill, my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, tomorrow morning, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.